Good evening, viewers. My name is MC Chaka. Welcome to another edition of Legal Hour. Legal Hour is a program designed to educate Ghanaians and people from diaspora living in the UK, most especially about legal matters confronting them. This program is sponsored by CITI Law Solicitors, and they've been our backbone from day one. Legal Hour we bring to you every Tuesday from 8:30 p.m. We're here today and we've got another issue, another topic to discuss. I'm here with my usual guest, lawyer Thomas Beyebenwo from CITI Law Solicitors. I'll be introducing lawyer very soon, but before then, please stay tuned. I'll be right back. Stay tuned. Welcome back, viewers. Legal Hour, time with MC Chaka and lawyer Thomas Beyebenwo from CITI Law Solicitors. Lawyer, good evening.
Good evening.
Speak up a bit, please. Welcome to the show.
Well, thank you, MC Chaka.
Yeah.
Listeners and viewers, once again, it's a privilege to be here, and I'm sure that MC Chaka will bring up what we are going to discuss today. But I want to shout out thank you to everyone who has just joined us and who has always been there. We hope that you guys will share the videos to your friends and family. And obviously, I'm sure DJ Chaka is going to discuss a little bit about the brand new radio station. So I leave it to you to handle that aspect.
Okay, that's fine. So today might be first time that maybe some people watching this. You might telling us as an intro where you are based, your firm, and what you specialize in, please.
Thank you. Well, my name is Thomas. Most of you are already familiar with me. I'm a partner of CITI Law Solicitors. CITI Law Solicitors is based at Barking, Unit 113, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 118FG. If you want to reach us on telephone, our office contact number is 02033 550782. And we specialize in numerous areas of law, immigration, family law, employment, personal injury and clinical negligence, commercial dispute and civil litigation, housing and consumer law. So our doors are always open to the public. Those of you who may need advice in these areas of law, you're always welcome.
All right, thank you very much, lawyer, for the intro, as you do all the time. So, viewers, tonight our topic is going to be on immigration bill and our rights, towards immigration bill. Lawyer, we know a lot of people have been detained lawfully or unlawfully by the Home Office as per the Immigration Act. And I know people might be subject to immigration bill as well. So when we talk about immigration bill, what is immigration bill, lawyer?
Yes, thank you very much, MC Chaka. I'm sure that those of you who have been following us over time will be aware that about 3 weeks ago or last month we looked at unlawful detention, and we discussed extensively people that may be subjected to unlawful detention, and we did our best to educate them on their rights. Today we'll be looking at bail applications or bail. Now obviously, I must say here that what we are looking at is not criminal bail. We are looking at immigration bail. So as MC asked the question. When we say immigration bill, it is those who are under detention are released temporarily, subject to certain conditions or restrictions. That's what we call bail, which means that that person is under detention or liable to be detained, and that person is released subject to conditions, which I'm sure we'll go through it in the course of time. So that is what we mean by immigration bill, and most people have right to this. We'll see why people do have right.
Okay, thank you very much for throwing some light on what immigration bill is. So my next question is, which people are entitled to the immigration bill? Because I know a lot of people might want to make application, but then they might not know their rights. Can you throw some light on which people that will be entitled for the immigration bill?
Yes, thank you very much. The point is that, as I've just defined what the immigration bill is, it then goes further to perhaps look at which people that will be entitled to this bill. Obviously, people that will be entitled to this bill are those who are under controlled immigration. The first group of people will be those who are liable to removal or further examination. Now, when we are looking at removal, those who perhaps are in detention, Home Office have set directions for their removal, or those who are coming in and then they are subject to further examination. That's one group of people that are entitled to bail. The second group of people are those who are subject to deportation order. So when people are yet to be deported, they are normally kept at the detention center. Such people are equally entitled to bail. So these are the groups of people that will be entitled to bail when they are under control immigration.
All right, thank you very much, lawyer. Last time, I think we've discussed, I think a bit of this topic previously, and that we spoke about unlawful detention and under War Act. But in regards to immigration bill, what government institution have the power to grant bail? And then what are some of the factors or the conditions that they can take into consideration if they want to grant someone bail whilst they are, subject to immigration conditions?
Yes, that's a very, very good question. The point is that people are always of the erroneous view that because they don't have leave to remain, and therefore if they are kept in detention, they cannot be released under any circumstances. The answer is no. Normally, there are certain things that are taken into account if somebody was to apply for a bail. So normally when you apply for bail, whether through the Home Office, which is the Secretary of State, or to the Immigration Tribunal, which I will look at it in the course of time, they take certain factors into account. And by the time I finish explaining these factors, most people will know that their family members who are still kept under detention are entitled to bail. The first factor that they take into account is whether or not that person is likely to abscond if he's granted bail. Second condition is whether or not that person has committed an offense, and whether or not if that person, again, the third condition is whether if that person, if granted bail, will commit an offense. And then also, they will also be looking at, especially for those people, remember I have just mentioned those who are subject to the deportation order. Those people might have committed heinous offense, They might have, they may be rapists, they may be murderers. So one of the factors that will be also considered is whether they pose risks to the public. So these are the factors that is normally taken into account. And I'm sure those of you who are listening to me, by the time you digest some of these, you will find out that there are a lot of people in detention who don't fall in these categories and therefore should be entitled to bail.
All right. Thank you very much, lawyer. Viewers, if you've just joined us, we're talking about immigration bill, the conditions that the Secretary of State take into consideration before bail could be granted. And lawyer has just thrown some light on what immigration bail is. We're going to continue, but before then, as I do all the time, let me acknowledge my viewers. Let me welcome people on board as well. Start from Tabi Takum, Kojantri, Tabi Takum, watching all the way from France. Kojo, I hope you're doing well. Thank you very much for watching. I know you were the first person to share this program. Please share and make sure everybody benefit from this program. Francis Apia Akwe, Yana, that's my cousin in Ghana. Kwesi Apia. Kwesi, thank you very much. I know you're very passionate about this, and you're very educated anyway, so I'm sure this is very good for you. Thank you very much, and I hope you share for others to benefit as well. Cornelia from Poma Jima, thank you very much. Cornelia says, good evening, City Law family. Happy to see you all. Good evening, Cornelia. Happy to see you too. I hope you're loving this program. Prince Atakra Nyamiche Tuswe is watching. Yo, that's my boy Prince in Ghana. #1 footballer in Ashanti Mampo. Yes, Prince, keep watching and make sure you share. Oba Ya Pokria. Oba, thank you very much for watching. Thank you, Mami. You, as always, please share for us. Thank you for watching. Nana Frema, good evening, lawyer. Nana Frema says, good evening, lawyer. Ebre Onyekule Ikuagu, sorry if I didn't get your name right. Ebere Onyekule Iguagu, I'm watching too. My sister, I've acknowledged you too. Thank you very much for watching. Thank you. So we're talking about immigration bill. This topic is very important. A lot of people have been in detention, as I explained earlier, on whether lawfully or unlawfully, and they've not been granted bail. They've been denied bail, and some of them, unfortunately, have been deported to their various countries. So this is very important. So lawyer is going to talk to us about what we can do, the process, the application, and what we need to do when we come into similar situations. So I'm going to go back to lawyer, and of course, we continue with the questions. But then, if you're watching, make sure you share this program. And then we've got our online program. Online radio is active at the moment, so you can listen to the radio as well. The radio is live. You can get the same program on radio, CITI Media Radio. You can get it from Modern Ghana. For those of you that are on my contact list, I've already shared it to you all. So Modern Ghana, when you go to the abroad section, CITI Media Radio, you can get this program live on your radio. So if, let's say, where you are, unfortunately, you can't watch it, whether you're driving or if you are cooking or you're doing something that will prevent you from watching the video or from Facebook, you can always listen to the radio as well. CITI Media Radio, so it's live on the radio as well. We thank God the radio is active. So I'm going to go back to lawyer, and with more questions coming on the way. Lawyer, so you mentioned that the Secretary of State takes certain factors into consideration before they can grant bail. And you spoke. I'm quite happy to hear you talking about the criminal bit and then obviously the non-criminal aspect of it, because we know last time you explained that we've got deportation and removal, and then if I'm correct, you said the deportation is applicable to people who have committed some form of crime, and then obviously they've been to prison, and after that they've come to detention, they become subject to deportation. But then removal is people that have unlawfully come to the UK and that needs to be sent back to their country. Is that correct?
Exactly.
Okay, good. So we've got people who have been detained lawfully and unlawfully in detention, what do you call it, unit or detention camp. So whilst they are there in the camp, and if you are a relative, how would you know that this person or your family member or yourself will be eligible for a bail? How would you know?
Yes, that's a very, very good question. And again, I'm glad that people are following this area of law. Normally, if someone is in detention, irrespective of these categories of people that I have looked at, which you have rightfully created a distinction between them, which is those who are foreign criminals and those who are just subject to removal directions. Now, the Secretary of State, which is the Home Office, has a duty that within 4 months of that person being in detention, they have a duty to consider a bail for that person. So which means that if you have a family member, for whatever reason, who has been there for this period, and in fact, there are other areas that we also consider barriers to bail and all that. But the fact is that once that person has been there for 4 months, automatically there is a duty on the Secretary of State to consider bail application for that particular person. And that's why sometimes people are just released and people go, oh, it means that Secretary of State has considered that within 4 months, and then they sometimes, if they don't do it, they are breaching that right, and that person has a right to fight for that bail.
So, lawyer, within 4 months they need to be released. But the fact is, if they don't get released, that means they'll be deported.
Within 4 months, they need to be considered for bail. They have a duty to be considered for bail. And obviously, bail is people who are released on conditions.
Yep.
Yes.
Okay. So, can they be released before the 4 months period then?
Of course, yes. Normally, people are entitled to make these bail applications either to the Home Office with the Secretary of State or to the Immigration Tribunal. With the Immigration Tribunal, normally when you make a bail application, then you have to wait for more than 28 days before you make another bail application. But with Home Office, as your circumstances changes, we can always put in your bail, depending on the circumstances.
Okay. So, lawyer, let's say my family member has been detained and we want to make, or we've made application for bail. How long does it normally take for the application to go through, for the person to be considered for bail?
Yes. Again, this is an area that sometimes people's rights are breached. And as I've said from the beginning, CITI law says we are taking the fight to the border. Normally, when you make a bail application, you have just 10 working days to receive response. Again, many times it will take weeks and then people don't get that response. When that happens, in itself, it's a breach of that person's right. And that person can consider what they call judicial review, which is a further barrier to removal.
All right, thank you very much, lawyer. Tonight we're learning a lot because I've witnessed a lot of people being detained, being deported without knowing their rights. So this is a very good program for all of us to know what we need to do when we encounter or confront ourselves in similar situations. So lawyer Thomas Beyebenwo from CITI Law Solicitors is here with us this evening, and he's giving us step by step the process, what we need to do, obviously, to be granted bail or to make bail applications. So, lawyer, who do we make the bail application to, and where can we find their details? Because normally people don't know their right, they don't know who to make the application to. Some people might think maybe it's the Home Office, some people might think they have to go to the court. Can you clarify, can you throw some light into who the application can be made to? What institution do we have to make the bail application to?
Yes, that's quite a good question. Normally, when you are making a bail application, perhaps it's better to go through the stages. So the initial stage is to make the bail application to the Home Office, but simultaneously you can also make bail application to the Immigration Tribunal. And normally, if you want to make bail application to the Home Office, when people are intercepted or apprehended or are detained, there is normally a form called IS-96, which used to be normally used to call temporary admission form. Those details will be there. So the caseworker's details or emails about those contact details will be there. So, and it's important that people take notice of this, because if you send your bail application to the wrong department, then you may not even receive response at all. But for whatever reason, you could still be waiting in detention for a very long time. So it's important that bail applications are made to the right people who are the case owners of that detention matter. And possibly, if you also want to make to the Immigration Tribunal, every detention center is also affiliated to some immigration tribunal. So it's not all the tribunals that can deal with. So, for example, if you are detained in Hatton Court, then perhaps you have to go to the Fairtown Immigration Tribunal. So those are the areas that people need to take into account when they are considering making bail applications.
Okay, that's fine. So lawyer has given us what we need to take into consideration and where we can make the application, what form we need to. But lawyer, what would you say to people who would like to do it by themselves? Because I know this is a very, as you said, if you're not careful and you send it to the wrong department, I mean, you could be in detention forever. And if you're not lucky, before they pick you up, you'll be deported already. So what advice would you give to viewers who are watching and listening right now that they should do when they come into contact, when they confront themselves in such situations, or even their families? What should they do?
Well, obviously, as I always make this analogy, if for example, if you are sick, you can't just give yourself self-medication. You obviously need to consult your GP or possible pharmacist to be giving the right dosage. Now, bail applications are slightly complex, because if you just make it without considering the barriers to that removal, then of course, if removal is imminent, as we discussed last time, then that bill could be refused. But of course, most of you watching us are aware, some of you might have even instructed us to deal with bail application for your families. So there are other lawyers who are equally available that can also assist. But I would not say that people should do those applications themselves, because it's slightly very complex area of law. And if it's not handled properly, those people should be removed. Remember the case I was talking about the client I dealt with about I think 5 weeks ago, when he was almost on the flight.
Oh yeah. I remember that.
I had to make a bail application for him to be removed from the flight.
Yeah.
And be joined to his families.
Exactly.
These are some of the wonderful things that we can apply the law and then help people to get their freedom.
Okay, lawyer. Just bear with me, a little bit technical issues. I'll be right back. Just bear with me. But yeah. So please continue. What are some of the conditions that could be part of the bill? If you are applying for the bill, what are some of the conditions that the Home Office or Secretary of State can put it as part of the bill? What conditions comes with the bill?
Yes, this is the area that I want people to take a very good note of. Because when people, obviously, immigration bill, they will be released subject to conditions, and those conditions are unlimited. For example, I will take viewers through a few of them. They could ask that you should reside at a particular address. That's one of the conditions. Another condition is that they can say that that person should not work. That's one of the conditions. In fact, there could even be electronic monitoring tag, which are tagged to people who are serious criminals that are subject to deportation, for example. There could also be reporting conditions where people have to either phone in or report to a particular center at a particular time. But I want to make a very significant point here. Now, just as we look at unlawful detention, bail conditions sometimes can also become unlawful. And if I could just highlight, these are supported by case laws. If you look at the case of Albi versus the Secretary of State 2015 Court of Appeal case, it says that bail conditions should not be imposed when people are not liable to detention. So, for example, if there are barriers, and I've seen a lot of people who have been, for whatever reason, maybe they had their leave, they are returning from holidays, home office, perhaps revoked their leaves, and then those people were subjected to very strict bail conditions. For example, they should not work. Now, if your application or your leave is revoked, and then you have appealed that decision, if that decision is pending, that means your paragraph 3C right, which most immigration lawyers, paragraph 3C of 1971, which immigration lawyers are familiar, kicks in. So where Home Office is asking you not to be working, it's obviously unlawful, because you are no longer liable to detention. Your appeal is pending, even though your leave has been revoked. And I have personally dealt with clients that I'm still representing, when those conditions are put. And I ask, most times I just write to them, look, you cannot subject my client to this condition because it's unlawful. So these are some of the rights that people have, and they are not making use of them, either out of ignorance, because you cannot subject somebody to very strict bail condition when that person is not liable to detention. So that is the answer to the question you just asked.
That is a very good explanation you've given to this question, lawyer. Because in my line of practice, I've seen a lot of service users that they've been subject to a lot of conditions, and it becomes very difficult for them. I mean, sometimes they've got family, and what to eat becomes a problem. We need to rely on charity organizations even to support them financially, to give them food. I mean, it's really pathetic, So well done on that. So, I mean, let's say if the conditions are lawful, I'll come to the unlawful bit, but if the conditions are lawful, for instance, no right to public recourse, not to work. These are some of the conditions that will be faced when some people have illegally come to this country without any public recourse or any work permit. So the Home Office will automatically say, you are not eligible to work. If these conditions are there and the person breaches the condition, the lawful conditions, what will happen? What will be the possible consequences of breaching the conditions that are lawful?
Yes, as I set out from the beginning, obviously, immigration bail is when people are released, people under detention are released, subject to certain conditions. So if those people, for whatever reason, they breach those conditions, then they are likely to be detained. They are liable to be detained. So that's why I was advising that instead of breaching the conditions, and along the line, I'm going to explain to people why instead of breaching the conditions, they can rather apply to vary those conditions. I have pointed out that some of the conditions might not be valid or lawful. Those conditions can be applied, application can be made to vary those conditions rather than breaching them. But I'm sorry to say that breaching the conditions has a consequence of being liable to detention.
Okay, lawyer, I'll come back to you on that. Breaching the conditions could bring a lot of problems. We're going to go for a short commercial break to resolve some technical problems that we've encountered. I'll be right back. Please don't go away. You can join or you can listen to us on Facebook or CITI Media Radio. I'll be back right now. Please don't go away. Please don't go away. welcome back to CITI Media. My name is MC Chaka. I'm the host of this Legal Hour program. I'm here with lawyer Thomas Beyebenwo from CITI Law Solicitors. This evening we're talking about immigration bill and the conditions that lawyer has just outlined. Before we continue, I'd like to acknowledge some of my viewers. I know they've been testing that Chaka. We need acknowledgement. Yeah, that's fine. Nana Frema, good evening, lawyer. Nana is watching. Cornelia is a great admin to this program. Cornelia is watching. KD Jomo, my friend KD from Ghana. KD is watching live from University of Ghana. Thank you very much, KD, for watching all the time. Make sure you share to others. Ella Otain, good work, lawyer. Thank you very much, Ella. Nana Frema, good work, proud. CITI Law Solicitors, you're always the best. Thank you very much. Thank you. Nana Ajele, I've learned something. That's good. Very educative, Nana. We are all learning something. Knowledge is very important. And I respect one thing, that wherever you live, you need to make sure that you abreast yourself with the law, with the policies, so that if any changes comes, you know whatever is going. And that is the basis of this program. That lawyer has dedicated himself and firmly supported by CITI Law to bring this to you every Tuesday from 8:30 and Thursdays from 8:30 as well. That's the tree version. To educate or throw some light into some of the changes, the policies, or different aspects of law, which I'll mention to you. Let me continue to acknowledge Amma Ampo4J. Great insight. Thank you very much, Amma. Thank you for watching. Amma is the host for Wuntumi Apomudin Nkomo. Yeah, thank you very much for watching, Amma. Cornelia says, sure, Amma, please share to others. Yes, Cornelia is a great admin to this. Thank you very much, viewers. We continue. So I'm here with lawyer, and we've got a lot of questions coming up for immigration bills and the conditions. Lawyer has just explained what conditions that could come. He mentioned the tag, he mentioned the work no right to work, no financial support, to live in accommodation. These are some of the conditions that come with the immigration bill. And some of them, as lawyer said, are very, very horrible. It can put clients or people into a deplorable situation. For instance, if they don't have any income, they don't have money, they don't have any support, and they don't give them the right to support. So this is the reason why when you come into similar situation, you have to contact CITI Law, because lawyer says he can challenge them and put some of the conditions outside. They can take it off, that it shouldn't be applicable to you because it might be lawful or unlawful. For the purpose of this program and for the sake of those who have just joined us, I'm going to let lawyer explain or throw some light into why some of the conditions cannot be lawful. Because some of you think, we know what we're doing. This person is unlawfully living in this country, or we've got every right to detain this person, and we think these conditions should be in place to mitigate the person's risk of harm. So they could challenge it. But lawyer, why could these conditions be unlawful in your perspective? Why can they be unlawful, the conditions?
Yeah, thank you very much. As I was saying, obviously, when people are released from detention on bail, they are subject to conditions. And some of the conditions can be very unlawful. Because if you look at the case of RB, versus the Secretary of State 2015, which is a very established Court of Appeal case law, he says that the bail conditions should only be imposed when people are liable to detention. And I will tell you why certain people are not liable to detention. For example, removal is not imminent. For example, and I know that some people go through a lot of suffering because of some of these conditions. Let's take, for example, somebody who has a residence card or is a spouse of EU residence cards. A spouse of EU national. Maybe, or some people, sometimes when they go on holiday, on their return, they are stopped, they interview them, they take their passport from them, and then they release them on bail and give them various conditions, some of which will be that they should not work. Now, let me just explain why some of those conditions cannot be lawful. Now, if you have a residence card, for example, or EU settlement scheme, limited leave to remain, and then you have been stopped coming back from holiday, and then your leave has, for example, been revoked, and then you are released on bail. Now, once you have put in an appeal, that means that according to the Section 3C of the 1971 Immigration Act, your leave is restored until such time that the tribunal has finished adjudicating the case, or there has been a final determination on that appeal. So under those circumstances, those people who are appealing this decision will not be liable to detention. And therefore, if Home Office set condition that they should not work, they are breaching the law. The reason they are breaching the law is that that person now has recourse to paragraph 3C right. That person is not liable to detention. So under what circumstances are you imposing such draconian conditions on that person? But it's very common. It's all over the place because people don't know their right. And I have personally had clients who have been in those situations. They ask me, look, work. I have challenged some of these decisions with the Home Office because they know it's unlawful. But they are looking for somebody to tell them the right thing. That's why I said now we are taking the fight to the border.
All right, we're taking the fight to the border because lawyer has done or dealt with a lot of cases that people have been unlawfully detained and he's got them out. So please don't sit there when your relative or maybe yourself come into this situation. I mean, CITI Law Solicitors is for you. Please contact them and then your immigration matters will be resolved. Lawyer, for the benefit of time, let's move on with the questions. So I've heard of financial conditions as part of these bail conditions. So why is it required for bail applications, financial conditions?
Yes, normally the financial conditions are imposed with a view of ensuring that the bail conditions will be complied with. So the decision maker who is making decision on the person's bail may decide to impose a financial condition, and under those circumstances, the amount and then how much that person has to provide as a surety will be provided. So the financial condition is normally imposed with a view to ensuring that those bail conditions are complied with.
So to add up to that, if somebody or if that condition is imposed and the person cannot meet the financial condition, cannot get anyone to support with that, I mean, what will happen? Does that mean that the person can never be granted bail?
No, not at all. Obviously, there are various alternatives to the financial condition. If the person has a permanent address or a family member is willing to provide accommodation, financial condition is very, very, very limited in terms of its usage when bail conditions are being considered. Because even from my own experience from practice, I have never seen a case where those financial conditions have really been imposed. And even those that they did, they've never been any way of enforcement. So if somebody doesn't have it, obviously when you are seeking bail, you are trying to demonstrate that you comply. So if you make all those proposals, it enhances the person's chance of getting that bail.
All right. Thank you very much for clarifying that, lawyer. So people that are granted bails, can Home Office have a duty or any consideration to provide accommodation for those who might not have a place to stay after their bail?
Yes, the Home Office obviously under the Immigration Act 2016 have a duty to provide accommodation where that the person has no address, and that person cannot be supported if he was to live at that particular address. So under those circumstances, Home Office has a duty to provide accommodation for that person being billed.
Okay, the reason why I'm asking this question, lawyer, sometimes people will be released and then they might not have anywhere to stay. So would there be a situation where Home Office says, no, it's not our responsibility to give you a place. If you don't have a place, it's your own responsibility. And if that happens, what can the person do?
Well, as I've said, I don't say these things in vacuum. This is provided by law, that the Home Office have a duty to provide that accommodation under the circumstances where there is no way of that person getting accommodation or being supported on that address that he's being billed to. Then under those circumstances, if that person has fulfilled the conditions of being granted bail, then Home Office has the duty to provide that person with accommodation. And this is enshrined in law.
Okay, that's good. Thank you very much for clarifying that. What about financial support, especially for people that need to transport to the detention centers to sign? What sort of support can Home Office provide financially?
Yes, you see, that's why I was talking about the fact that some of these conditions are unlawful. There are many times that people who have been asked to report at the center. At the same time, those people have been asked not to work. Now tell me, where would these people get money to travel to the detention center? But again, there is also provision that if those people cannot get any funds to transport themselves to that reporting center, then they are entitled to contact Home Office for that financial support. Again, this is a right that most people don't exercise it. So that's why I said that instead of people breaching the condition by not reporting, they could simply would have made the argument to Home Office, look, I don't have funds to travel to go and sign on. Then it will be up to Home Office whether they want to remove that condition or provide financial support. So these are some of the rights that people hardly exercise it, but they are entitled to exercise this right once they are on bail.
Like I'm sure a lot of people don't report to the centers because they think sometimes if you do report, they might not come back home. They're probably going to take them to detention again and then deport them or remove them from the country. So I'm sure most people don't do do that based on that fact, not really the financial aspect. But anyway,
I think I want to just comment on it's a very, very good point that you have raised. Now, let's look at it this way. Now, if people are not reporting, obviously, they have breached that condition. The danger is that those people have two options. They either go by the safe route or they get themselves in trouble. The danger is that whoever is subjected to reporting condition and doesn't report, then if that person is apprehended in future, there is more likely to be quite a lot of hindrance in getting bail for that person, because Home Office will be arguing that when they grant bail, that person will have scorned because they didn't abide by previous bail conditions. But instead of breaching the condition, it is rather better that those people exercise their right. As I've said, if they don't have means of transportation and they don't have the finance for that, then they could make a case to Home Office that, look, I don't have money to pay for transport. It's then up to Home Office whether to remove that reporting condition for them or provide finance for that. But simply not doing anything about it or exercising your right might pose some danger if, for example, they are apprehended in future. And I'm sure whilst we are going through this, we'll see some of the powers of the police and the immigration officer when it comes to those subject to bail conditions.
All right, viewers, if you're just watching us, this is Legal Hour with MC Chaka, and of course I've got in the studio lawyer Thomas Beyebenwo from CITI Law Solicitors. Tonight's topic is immigration bill, very interesting topic. A lawyer has given us conditions. He's spoken about when bill can be granted. We've spoken a lot about what constitutes immigration bill. So tonight's program is very educative. Please make sure that you invite your friends, your family to enjoy this program. Make sure that you share for them to benefit from this program as well. And then also, this program is live on CITI Media Radio. I know Senior BM just sent me a message, goes, I'm listening live. Senior, thank you very much. I know you're at work right now, so obviously you'll be able to enjoy or benefit from the radio section. This is the reason why we added the radio to the Facebook channel. So the radio is very operational, and you can enjoy that as well if you're not able to watch from Facebook. Let me acknowledge a few viewers, and then we'll take a commercial break. Bantus, I do apologize for not returning your calls. I know you've been sending me messages, but I do apologize. I'm glad that you're watching this program. Make sure you tune in and subscribe anytime we come. Okay, so we've got Chilotam Louisa Ubuagu. Nice one. Thank you very much, Chilotam. Ella Otin is watching. Cornelia from Pomajima, great Chaka, great job, always on point and summarizing at every stage of the interview. Keep it up, bro. Thank you very much, Cornelia. You did very well as well by means of acknowledging people and obviously sending comments. Thank you very much. Viewers, if you have any question, we will open the phone lines, but I can still read your questions at the comment section. So please make sure that you drop your questions and I'll definitely read them for you. I'll read them for you. So let me go through. KD Jomo, KD is still watching. Prince Atakura Nyamiche Tusway. Prince, I hope you're doing well. Good luck with the football. We're solidly behind you. Obaya Pokia, Mami Yu is watching. Ama Ampofo J. Ama is the host of Apomudin Komo on Ultimate TV in Ghana. Ama is watching. Dada Bequeen, good evening, boss. Da Queen, good evening. Thank you very much for watching, Da Queen. And my brother Akwesi Apia, Yana Akwesi Apia, Francis Apia Kubi. Francis is also watching. We're going to go for a quick commercial break. When we come back, we've got more questions for lawyer. And then I know time is gone, but then we've got about 10 more minutes and we open the phone lines for viewers to also throw some questions. But you can drop your questions at the comment section, as I said. So we're going for a quick commercial break. Please don't go away. Stay tuned. We'll be right back. Welcome back. Legal Hour. This is where we educate ourselves with immigration matters. And this program is proudly sponsored by City Law Solicitors. We've got lawyer Thomas Beyebenwo in the studio. He's taking us through the immigration bill conditions. We've spoken about people who are entitled for bail, whether the Home Office have a duty to arrange consideration for bail. We've spoken about who do we make the bail applications to, what conditions can the bail constitute, what financial conditions obviously can be part of the application, and whether those granted or bail will be subject to financial assistance or maybe housing or accommodation support. So we're going through the questions step by step. Lawyer, when people, or when someone is on bail, when does the bail end? Can the bail end, or maybe the person can be on bail forever? Is there any end date for the bail?
Yes, that's a very, very good question. As I was explaining, this is also intertwined with the unlawfulness of the bail conditions. Now, bail will normally end if that person, bail conditions, will normally end if that person has been granted leave to remain, or if that person, circumstances have changed, for example, depending on the circumstances, if he's entitled to some form of leave. Or if that person is detained, obviously if you are detained, your bail condition has ended. Or if that person is removed from the United Kingdom. So these are conditions that brings the bail conditions to an end. But having said this, that is why it's also significant to look at the unlawfulness. And as I've said, you could see that when I was talking about ending bail conditions, I spoke about those who have been granted leave. Therefore, those people who were initially subjected to bail conditions because their leave, again, as I said before, was revoked. Once they've submitted an appeal, then obviously their leave is reinstated until such time that there is a final determination on the appeal, whether it's allowed or dismissed. So under those conditions, the bail condition should end. But there are a lot of people who are in this situation and they are still not working because they have been told not to work as part of their bail conditions, when in fact that condition has ended indirectly by the change of their circumstances. So this is why I said that there are a lot of people who have been subjected to unlawful bail conditions, and some of them need to look into it and seek proper advice on it.
All right, thank you very much, lawyer, for clarifying this. There's one thing I want to talk to you about or speak to you about in regards to the bail conditions and whether the person will be brought back to court or the tribunal. Once people are on bail and conditions are imposed, and let's say they are complying with their bail conditions, if there's a hearing or if Home Office, if there's a court due date or hearing and the person attends and the Home Office or the court rules that the person needs to be deported or removed or whatever the court will say, would the Home Office act immediately, or the person could be given some time and obviously be taken back later on? And what can you do in your capacity as a solicitor to support such people who confront themselves in such situations?
Well, in reality, it would be quite bizarre for such a thing to happen, because normally when you go for a hearing, it's only few, maybe 1 out of 100, that a judge will make a decision on that day. Decisions are made maybe within 3 weeks. Sometimes you even wait for decision for about 2 months before you finally get a decision. Now, while decision has not been made, obviously Home Office cannot enforce any removal direction or deportation order against that particular appellant. And even if decision was to be made on that day, that person may also be able to appeal the decision, because he may be entitled to appeal that decision. So it is quite unlikely that somebody subject to bail whilst going for hearing could simply be apprehended. It's unlikely to happen under those circumstances.
All right, thank you very much for clarifying that. And then also, can people on immigration bail be arrested without any warrant? And what could cause that?
Yes, This is very, very, very significant, and again, that's why I kept on hammering on people exercising their right. Because if you don't exercise this right against the lawfulness of those bail conditions, then it becomes a problem. The reason it becomes a problem is that under the Immigration Act 2016, when people are subject to bail conditions, they can be arrested without warrant. So, which means that either the immigration enforcement officers can just enter into the premises and then enforce, take that person to detention, or the police can do that. But having said this, let me make one point clear. The point is that those of you who are in your houses and then immigration officers are seeking to enter and come and remove you from there, I want you to know that it is only those people who are under bail conditions that can be arrested without warrant. And I have seen people who are jumping through windows. You don't have to jump through window. Don't open that door. Because
oh my God.
That person, enforcement officer, hasn't got a warrant. And therefore, if the door is not opened, he's not going to break into that door. That would be quite unlawful. So the point is that people should know that it's only those who are subject to bail conditions. They are the ones that the police or the immigration enforcement officers can just enter their premises and then arrest them and detain them. They cannot do similarly the same to those who are not under those conditions, are not subjected to those conditions. So those of you who are family members whom these guys stem up and then you start panicking and jumping through windows, next time don't jump through the window. If you have a situation like that, you can call city law solicitors and we'll let those officers be aware that they have no right to intimidate you or to those
lawyer. I mean, it's very funny, but obviously, it's very serious too. Let me come in because there've been a lot of situations where people would run away when they see even the police on the street. You know, because they think at that part of Europe, when you see police, they approach you, your papers, you're prepared. If you don't have it, you're in trouble. So a lot of people have that same ideology that, oh yeah, this is applicable in this country as well. So what advice? You've thrown some advice on people who probably might be living with people who are subject to conditions. But then generally to public people who are not got right to live in the UK, if they see the police or if they are confronted with such situations, please advise them what do they have to do.
Well, technically, as I've said, I have sometimes been stopped by the police because you know they have. I'm sure you are a probation officer, so you are probably more versed in this area. Mm-hmm. Police have powers to do what they call
stop and search. Yeah.
So those powers. The police already have those powers to do those stop and search. Mm-hmm. So if they meet you on the street and you were driving or for whatever reason, even under the criminal, the Peace Act,
yeah.
Yes, police have powers if they suspect you to be in a particular place that they think you should not be there.
Yeah.
Or if they suspect that your presence in certain place needs to be accounted for, under the criminal act, they can do those searches. But the important point I was making is that under the Immigration Act 2016, there are certain places that officers need warrants to go into such places. For example, if they are going to some workplaces to go and do enforcement. Similarly, if they are coming to your house. So, again, people who are accepting people who are being granted bail to their addresses, they need to take this into account because once that person is under bail condition, either the police or the immigration enforcement officers can enter the premises without warrant. But my advice to those who are jumping through windows, who are not subject to bail conditions, is that those people haven't got those powers or warrants to enter those premises. So don't open that door. Because at the end of the day, people have a right to liberty under the European Convention, and that's why you see that hardly will people be going to the immigration officer will be going to people's houses. Normally, people that they've gone to their houses rather because they've been released on bail and they've absconded, and then they turn up to that address. But if that is not the case, and somebody has turned up to your address,